Good afternoon, everyone. We are so excited to have you with us today as we discuss the No Surprises Act. We have a very full session, so we are going to go ahead and get started this morning. And thank you again for taking time to be with us today. The Federal No Surprises Act, passed by Congress in 2020, protects patients from receiving surprise medical bills resulting from gaps in coverage for emergency services and certain services provided by out-of-network clinicians at in-network facilities. The legislation also establishes an independent dispute resolution process in the event disputes regarding reimbursement arise between providers and insurers. Many physicians will be affected by the NSA, including emergency department practices, anesthesiologists, radiologists, pathologists, and hospitalists. We have partnered with Stites and Harbison Law Firm to provide a comprehensive overview of the NSA and what steps should be taken to ensure compliance. A few housekeeping items before we begin. This activity has been accredited for CME, and all persons involved in the planning and presentation of the materials disclose no relevant financial relationships with ineligible companies. This event is being conducted as a Zoom webinar, and as such, your camera and microphone are disabled. We do encourage you to utilize the chat and Q&A functions in Zoom, and we will try to answer as many questions as possible at the end of the presentation. Our speakers for this session have extensive experience in healthcare law and are very familiar with the provisions of the No Surprises Act. Dustin Jones is a member in the firm's healthcare service group. She devotes her practice to healthcare regulatory compliance, physician and hospital contracting, and practitioner payer reimbursement and coding disputes. She advises clients on regulatory issues related to the Stark Law, anti-kickback statute, HIPAA, and much more. Dustin also has experience representing individual providers and practices on insurance and governmental payer reimbursement, overpayment, utilization, and coding disputes. Shay Luna is an attorney in the firm's Lexington office, where she is a member of the Healthcare Service Group. She devotes her practice to healthcare law, focusing on regulatory and compliance, insurance, and data privacy and security matters. Shay's healthcare law experience also includes physician self-referral, licensure, and certificate of need, telehealth, medical staff, and peer review. Shay is certified in healthcare privacy and security with the American Health Information Management Association. We're very excited to have both of you with us today. Dustin and Shay, thank you again for taking time out of your busy schedules to be with us and speak about this very important issue. With that, I will turn things over to you, Shay. Shay, I'm so sorry, you're muted.
Sorry about that. Thank you, Miranda, for that introduction. Dustin, do you want to put up the slides? Okay. Miranda, can you put up the slides? Thank you. So as Miranda said, we're going to speak to you today about the No Surprises Act. Basically, this is going to be a primer of what you need to know and how it will impact your practice going forward. So the table of contents, what we hope to cover today is a background on the law, the requirements, and then really get into the meat of the law as to how it will impact you, which is what happens when you submit a claim going forward when you provide out-of-network services. We will also get into the good faith estimate requirement and end with some takeaways on what you should do now. So what is the NSA? As Miranda said, the No Surprises Act is a federal law that prohibits out-of-network providers from balance billing commercially insured patients in certain circumstances. And balance billing is basically the practice of billing the patient the difference from the provider's bill charge and the amount paid by the insurance plan. The NSA also establishes a methodology for determining the patient cost sharing when you do provide out-of-network services, if that patient cost sharing is not established by state law. And it also provides a methodology and independent dispute resolution process to determine the health plan payment for those services, as well as some other things that you could see here on the slide. So how was the NSA implemented? Last fall, the Department of Health and Human Services issued 2 interim final rules and regulations. Part 1 and Part 2, which is the bulk of the NSA. Part 1, effective of January of 2022, it set forth the prohibition on balance billing as well as the methodology for cost sharing, and then it allowed for a process for obtaining a consent to balance bill in limited situations. This is what the regulation calls the notice and consent process. HHS also required in Part 1 that healthcare providers and facilities notify consumers of their NSA protections, and that is called the disclosure process. Part 2, which Dustin will touch upon, will cover the independent dispute resolution procedures, also effective this past January, as well as the good faith estimates that are now required for charges for scheduled self-pay and uninsured patients, and a process for disputing the charge if the patient thinks that is in excess of the estimate. That too was also effective in January. HHS has indicated that they also intend to come out with a good faith estimate process for insured patients, but that has been delayed. So who is covered by the NSA? The individuals and entities covered by the NSA are group health plans, and that is fully and self-insured health plans, group and individual health insurance insurers, federal employee benefits health plans, and then healthcare providers and facilities, and air ambulance service providers. Notably, the NSA will not apply to Medicare, Medicaid, TRICARE, Indian Health Affairs, and Veteran Affairs insurance plans because those plans already prohibit balance billing. That's going to come into play, that caveat's going to come into play when we talk about the disclosure, so just keep that in mind. So what services are subject to balance billing? There's 3 categories of services for which you cannot balance bill. Those are non-emergency services provided by an out-of-network provider at certain in-network facilities. Those certain in-network facilities are hospitals, including hospital outpatient departments and critical access hospitals, and ambulatory surgical centers. That's the first bucket. The second bucket is emergency services and related post-stabilization services. If the emergency service was provided with respect to an emergency medical condition by an out-of-network provider at a hospital or freestanding ED. An emergency medical condition is a medical condition that's defined, as you can see on the slide, and basically it's a situation where you are in serious jeopardy or there's serious impairment to a bodily function or serious dysfunction of an organ. For the most part, that's going to cover most all of your emergency services. Where the NSA extends itself is it extends it into the post-stabilization service that is in connection with that emergency visit. That can be an observation service, that could be an inpatient admission, other outpatient care, that's all tied to that emergency visit. So those types of services are also prohibited from balance billing. The services included in the emergency are those to evaluate and stabilize the patient, including any medical screening. The final bucket is air ambulance services provided by out-of-network providers. So how are these non-emergency services at in-network facilities reimbursed? So the basic rule is if you are an out-of-network provider and you treat one of the commercially insured patients that are covered by the commercial insurance plans we mentioned at an in-network facility, you can only collect the patient cost sharing from the patient that would be the in-network rate. You can't balance bill. So what does that mean? So if you're a non-emergency service, the health plan would require the patient to, let's say, pay a 20% copay for that non-emergency service. That is all the provider is going to be able to collect from the patient for that out-of-network service. The NSA has a very detailed methodology about how you calculate that patient cost sharing. It can be no more than the in-network rate. So, we suggest you get with your finance teams to start working through what that's going to look like. And the way you will be notified by the plan of what the patient cost sharing amount will be is when you submit a bill for a service. They'll either pay it or deny it within 30 days, but they will have to notify you of the patient cost sharing amount. So providers want to be very careful that they do not charge the patient more than the patient cost sharing amount. If you do, then you could be in violation of balance billing. There is an exception for balance billing in cases of non-emergency services at in-network facilities. If you provide advance notice to the patient and they consent in writing to be treated by the out-of-network provider and be balance billed, then you can balance bill the patient. But that is only in limited circumstances, which we'll see in our next slide. As it relates to the health plan payment, so set aside what you get from the patient cost sharing. For the health plan payment rate, that's going to be determined by the NSA unless the state law applies. So how are emergency services and post-stabilization service reimbursed? It's going to be the same type of situation. If you have an out-of-network emergency service provided to a commercially insured patient covered at the NSA at a hospital or freestanding department, the provider and the facility only collect the in-network patient cost-sharing amount and cannot balance bill. There is also an exception where the patient can waive the balance billing prohibition and consent to treatment by the out-of-network provider, and we'll get into what those are in the next couple of slides. But I will go ahead and tell you these notice and consent situations are very limited, but there are some exceptions. And then again, the health plan payment will be determined by the IDR process and the limits in the NSA unless a state law applies. So, what is notice and consent and how does that work? So, when do you obtain the notice and the consent? You must furnish it to the patient, and for the non-emergency services, timing is everything. If the appointment is scheduled 72 hours in advance, you have to give them the notice and consent no later than 72 hours prior to the date of the service. If the appointment is scheduled within 72 hours in advance, you can give the notice and consent on the day of the appointment, but no later than 3 hours prior to the appointment. That gets a little tricky. You can't just, if you are within the 72-hour window, you can't just assume, I will get the patient's notice and consent at the time of registration when they show up for the appointment. It has to be at least 3 hours prior. Those are for your non-emergency services. So what about your emergency post-stabilization services? When do you obtain notice and consent then? That is only allowed in very limited situations. First and foremost, the treating provider has to determine that the patient is able to travel using non-emergency and non-medical transport to a participating facility within a reasonable distance. Then you have to go through the notice and consent process. But the key there is that the consent will have to be presented to the patient 3 hours before the post-stabilization care is provided. The notice also has to inform the patient if there are any in-network providers in the facility that could provide the service and give the patient the option to be referred to that provider. The treating provider has to determine that the patient or authorized representative is in a condition to receive the notice and consent following the emergency care and stabilization. And then there's the caveat that even if you obtain notice and consent, if by chance the out-of-network provider has to provide an unforeseen, urgent medical service, they cannot balance bill. So in those situations, even if you have the notice and consent, you still cannot balance bill. So the notice and consent, what it looks like is thankfully HHS has provided a model. You can choose to create your own notice and consent if you meet all the content requirements, but you will deem to be in compliance if you use the HHS model notice. A few other considerations you need to keep in mind when considering the notice and consent is it must be provided in any of the 15 commonly spoken languages in the provider's region, or you provide an interpreter if they speak a different language. It's also going to have to include an estimate of the charges of the out-of-network provider or facility, and that the patient can revoke it at any time. Here is a sample of what the notice of consent looks like that HHS developed, the model form. As you can see, there's just a few spaces for you to include information applicable to your facility. The biggest piece will be the estimate, being able to get an estimate or obtain an estimate of what that out-of-network service will cost. So there are, as I mentioned earlier, there are only limited situations in which you can obtain the notice and consent, because the rule is very clear. There are some services for which notice and consent is not allowed. Next slide, Dustin. Yeah, thank you. So when you are providing a non-emergency service at an in-network facility, you cannot obtain notice and consent in these situations. If you are furnishing an item or service as a result of an unforeseen urgent medical need, you cannot obtain notice and consent. If the items or services are provided by a non-participating provider and there is no participating provider at the facility who can furnish the service, you can obtain notice and consent. It's not allowed for certain ancillary services if provided by a physician or non-physician, such as neonatology, radiology, pathology, anesthesiology, and emergency medicine. Also, assistant surgeons, hospitalists, and intensivists cannot obtain notice and consent, and diagnostic services are also excluded. So what does this basically mean? In a nutshell, for the notice and consent, it's very limited. So you need to be very careful that you're not trying to obtain a waiver in situations in which the waiver is not allowed. And the administrative burden is going to be pretty great. The timing requirements of 3 hours prior to a visit or 72 hours prior to a visit may be difficult. So you may want to consider, I am aware of some larger health systems who have opted not to obtain a waiver. It's not required, it's just an option. But I would caution you, if you do choose to obtain the waiver, to make sure you have a process that meets all the requirements and that you're doing it in the situations in which the waiver is allowed. You don't want to be caught trying to obtain a waiver in these situations where notice and consent is not permitted. So how long must you retain the notice and consent? In a nutshell, for both the non-emergency services and the post-stabilization services, it will be 7 years. The facility will need to retain it for 7 years. If the out-of-network provider is going to obtain it directly from the patient, they have a choice. They can either retain it for 7 years or arrange for the facility to do so. So how do you notify the insurance company that you are permitted to balance bill? When you submit the claim for the non-emergency services, the out-of-network provider or the in-network facility on behalf of the provider must notify the carrier, the insurance carrier, that they obtained, that they provided a non-emergency service at an in-network facility that was permitted by the NSA, and provide a copy of the notice and consent if requested. If the out-of-network provider bills the patient directly, they are permitted to provide the notice and consent with the patient bill. For the post-stabilization services in connection with an emergency visit, it's the same process. You notify at the time you submit the bill and then provide a copy if requested. So in addition to giving us a very few situations in which we can obtain a waiver to balance bill, the NSA also requires providers to notify consumers and patients of their balance billing protections, and these are called the disclosure requirements. And these apply to healthcare providers and healthcare facilities. And healthcare facilities, as before with the NSA, include your hospitals, your hospital outpatient departments, your critical access hospitals, and ambulatory surgical centers. It is important to note that, at least with respect to the disclosure, a healthcare facility also includes a hospital and freestanding ED. Now, as I said, the disclosure applies to healthcare providers, but only if the care is being provided at the healthcare facility or in connection with a visit to a healthcare facility. So if you are a primary care provider just providing primary care in your clinic, the NSA will not apply to you, and so you do not have to notify consumers of their NSA protections. In other words, you don't have to abide by the disclosure requirements. It is only going to apply to those providers who are providing care at these healthcare facilities. So who do you disclose, or how do you disclose? You have to provide a disclosure to the patient at the time of the visit. So you're going to have to give it to the commercially insured patients covered by the NSA when they receive services at the healthcare facility. This is where our exclusion of insurance plans comes into play, because if your patient is a Medicare or Medicaid, a TRICARE patient, those plans already prohibit balance billing. So the NSA says you do not have to apply the disclosure to them. You give the patient the disclosure, as I said. You have to give it to them at the time of the visit or no later than the time requested for the copayment. And most providers collect a copayment sometimes at the time of the visit, so that's why I was saying you need to give it at the time of the visit. But if you do not collect a copayment at the time of the visit, you just need to give them the disclosure before you send them the bill. HHS encourages providers to think about how best to give this to patients and to consider giving it at the time you give other notices, such as the notice of privacy practices. But remember, you have to give it to them before you request any sort of payment. As with the notice and consent, HHS has given us a model for a disclosure with instructions, and there's really no, if you follow this, you're deemed in compliance, and there's not a lot of information that you will have to fill in. It's pretty straightforward. In addition to providing the disclosure to the patient, you also have to post it on your website if you have one and at your location. Now, if for providers only, if your location, let's say you are an out-of-network provider working in an emergency room department and you don't really have an office or a location, you can partner with the facility, and if you execute a written agreement to have that facility or ED post the disclosure at the ED in their waiting room or wherever they post their other standard notices on your behalf. You still have to post it on a website if you have one, but you can partner with the facilities to provide that disclosure at their location, and if they're willing to do so. So that covers kind of, and then here is the model notice and disclosure, as you can see. So now I'm going to turn it over to Dustin. I covered mostly everything that happens before the claim is dropped, and now Dustin's going to cover what happens when you submit the claim.
Good afternoon. My name is Dustin Jones. Thank you, Shay. As Shay indicated, Shay, can you all hear me? Can you give me a nod? Okay, just making sure. As Shay indicated, I will address the post-providing the service issues and how those apply and to what practices and how under the NSA. So the first thing we'll talk about here are your claims determinations and when does the NSA apply. So these questions are going to arise once you get either an EOB or a remittance advice from an insurance carrier and you're wondering, you know, what you do, what applies, and what are your next steps. So after provisions of the services, you know, one of about 5 things can occur. You could receive your full bill charges from the insurer, and making a joke here about that, and the Peacocks and their Elite 8 run, which was unlikely, like receiving your full bill charges from the insurer, but maybe could happen. The second is provider receives a medical necessity or coverage denial from the insurer. You might receive a low payment, so less than your billed charges from the insurer. You might receive a coding or technical denial, or you could receive a grouping, a smattering of each one of these things at the end of a remittance advice or EOB, or you might just hear nothing. And providers, my clients are seeing any and all of the above so far. So what happens if you receive a typical medical necessity denial or coverage denial, just like you've seen pre-NSA under ERISA and the ACA in the past? The No Surprises Act is not applicable to those denials. So the NSA applies only to items or services for which benefits are provided and covered. So necessarily, if there's a medical necessity denial or a coverage denial, then you are not in NSA land. You are still in your typical commercial appeals process under ERISA or the ACA, respectively. The issue, the turning point is whether you've received an adverse benefit determination or a notice of denial of payment. Sometimes it's hard to tell the difference, and as I indicated, sometimes there's a blend of the two in an EOB or remittance advice. So your adverse benefit determination, for clarification, is a denial, reduction, or termination of a benefit failure to provide or make payment in whole or in part for a benefit, resulting from the application of utilization review, or because the benefit is experimental or investigational or not medically necessary or appropriate. The difference between the two, and kind of a rule of thumb to tell the difference between the two, is when you're looking at an adverse benefit determination, you're looking at it from the patient's point of view, and you're looking for a coverage or service denial. The patient's policy does not provide the benefits or cover the services. I get a lot of questions on, well, then how is a low payment not a denial in part or a failure to cover in part? And so you have to kind of illustrate that with an example of what is a failure to cover or a coverage only in part. And that is, for instance, like only a certain number of hospital days are covered under the policy, and those days in excess of that limit are not covered. And it's a denial or low payment. If you get a denial, so a zero payment, you're really looking at a coding or technical denial. It's not a medical necessity denial. A claims filing deadline, you didn't include a taxonomy code, something like that. So it's a provider billing mistake, and you look at it from, I think it's helpful to look at it from a provider point of view. So patient got their services, but provider on the back end had some kind of technical issue. So like I said, if you receive the adverse benefit determination, you're in ERISA and or ACA land going through your typical appeals process. But if you receive a notice of denial of payment or a low payment, then you were in NSA land. And if you want to fight the denials of payment or the low payments, instead of filing an internal and external appeal like you would under ERISA, you are now filing a series of documents, starting with a request for open negotiation and culminating in a independent dispute resolution arbitration. So we'll go over that. So a notice of denial of payment with respect to out-of-network emergency services, out-of-network non-emergency services at in-network facilities, or air ambulance services. And it's a written notice from the plan indicating that payment for such item or service will not be made by the plan. You may also instead receive a low payment, and that'll be an initial payment by the plan. And it's determined in the plan's discretion to be the out-of-network rate. The amount should be an amount the plan reasonably intends to be the payment in full, but it will likely be lower than the billed charges, and it may be lower. Remains to be seen. For my clients, it's varied, but it may be lower than your previous out-of-network payments that you've received from that plan. All right, so we're talking about the IDR process here. So if you do receive a low payment or a notice of denial of payment, and you want to fight about it, you want to contest it, you're now in the IDR process. And as I said, there's a series of steps, starting with an open negotiation period and culminating with an IDR entity choosing one of two alternate offers of payment. So we'll look at that in a little more detail here. The first step to the IDR process is a request for open negotiation. The provider, I've drafted all these slides from the provider standpoint, so the plan has some rights here and can also request open negotiation. But since this is the KMA, I've drafted this all from a provider standpoint. So the provider has 30 days from the date it receives the low payment or NDP, notice of denial of payment, to initiate the open negotiation period. Then after that, the open negotiation period itself is also 30 days. So you're looking at around 60 days after you received the notice of denial of payment or the low payment for that, first step to be the open negotiation period to be resolved. The provider initiates the open negotiation period by mailing or emailing the open negotiation notice to the insurer. That looks like this. It's pretty simple. You'll notice here on the first page on the left, there's some italicized language that the CMS intends for the practice to alter to fit the practice. This document is available at that link at the top of this slide. If the open negotiation doesn't result in an agreement, so the idea is, the plan and provider would agree during that time. If it doesn't result in that agreement, then you have 4 business days after the end of the open negotiation period to initiate IDR. And you can initiate IDR by filing a notice of IDR initiation in the IDR provider portal. You also must mail or email that to the insurer. This is the notice of IDR initiation, and that's the link where you can find it. Once IDR is initiated, the next step is for the plan and the provider to select an IDR entity. You have 3 business days following the IDR initiation to select which IDR entity and agree upon which IDR entity you want to use. There's a notice that's also on the DOL website, and that's linked to there. After you've selected the IDR entity, then the substantive step here is that the provider and plan both submit final offers. So this is what's called a baseball style arbitration. So the provider submits an offer that says this is this is the least amount I will possibly accept for these services, and the plan submits an offer that is basically, this is the most I am willing to pay under all circumstances for these services. And you have 10 business days after the selection of the IDR entity to submit these. And there are some details about how and what information you have to submit, which are indicated here. Included in the information you will submit is some additional information requested by the IDR entity and some additional information that the provider thinks is credible to support its payment offer. The additional information includes the provider's level of training, experience, and quality and outcome measurements, the market share held by the provider or facility in the geographic region where the services were provided, the patient acuity or the complexity of furnishing the item or service to the patient, the teaching status, case mix, and scope of services of the out-of-network facility, the demonstrations of good faith efforts or a lack thereof made by the out-of-network provider and the plan to enter into a network agreement, and any previous contract rates between the parties for the past 4 years. So we'll go over this in a little more detail a few slides from now, but the QPA is the default reimbursement rate under the NSA for out-of-network services. And the regulations set the QPA at the insurer's median contract rate. So when you're providing this additional information, what you are seeking to prove is that you should be reimbursed higher than the plan's median contract rate. So QPA, the IDR entity must begin with the presumption that the QPA is the appropriate out-of-network rate for the services, and it must select the offer closest to the QPA unless the credible additional information clearly demonstrates that the QPA is materially different from the appropriate out-of-network rate, and those materially different and credible additional information are terms of art in the law. So again, that's what you're seeking to prove. You can continue to negotiate with the payer during the IDR process. So after the request for IDR is submitted, but before the IDR entity makes its decision. And the rule there is just if an agreement is reached, then you have to submit notice of the agreement and some additional information through that same IDR portal. You can batch claims. So from an operational and cost perspective, this is an important point. If you do want to fight some of these lower payments that you may be getting, you can batch claims together. If they are billed by the same NPI or tax identification number, The payment will be made by the same group health plan or health insurance issuer. Note here that this is on a plan-by-plan basis. So to the extent you have self-insured plans that are just administered by, for instance, Anthem or United, it remains to be seen, but I imagine there will be some complications there where insurers may seek to unbatch claims because it's not technically the same plan. The claims include the same or similar items or services. The services are furnished within the same 30 business day period. And you may also separately for facilities, bundled claims may also be batched. So that those will be, of course, different services, but claims bundled in the bundle. So a little bit of a different rule there. After that, the IDR will make its decision and they will select one of the two final offers. It's due within 30 days of the date the party selected the IDR entity. It's just a written decision. And if they choose the QPA, all you'll get is a written decision noting they chose the QPA. I'm sorry, the offer closest to the QPA. If they choose an offer, if they choose the offer that is not closest to the QPA, then you'll get some additional supporting information, including what credible information the IDR entity relied on to make that decision. The decision is binding and it's not subject to judicial review by a court. So you're stuck with what the IDR determines. So you may be wondering what the impact on the practice's cash flow might look like because of the additional steps in the process. I provided a few charts here. This first one is a best case scenario. And it includes if you triggered all of these steps in the process within 24 hours of the date they could be triggered. Operationally, that's probably not feasible, considering your volume of claims, but you can see best case scenario here is if you provided services on January 1st, you might look at a final decision deadline, April 14th, for the payment amount. More likely timeline, giving a couple weeks between the steps to request open negotiation and request independent dispute resolution, you're probably looking more at like June 5th of 2022 for a January claim. This is further complicated if you have a medical necessity denial first. So remember, the NSA only applies to covered benefits. So you may see a situation where you have a medical necessity denial first, you go through the internal and external applicable claims appeal processes, the insurance company reverses, provides coverage for the services, and then issues a low payment. And so you go first through the ERISA appeals process, then you go through the IDR process if you want to fight that additional low payment. So now for a January 1st claim, you're looking at maybe a August 17th of 2022 final decision deadline and payment. Impact on reimbursements, negotiations, networks, and access to care. So immediately the law, there's a lot of good in the law. There's just some, from a provider standpoint, some, sticks instead of carrots. So immediately you'll see some the patients will benefit from prohibition on balanced billing. The provider may see decreased administrative costs related to collection of balanced bills from patients. There's increased transparency for patients regarding healthcare costs, and there's relief for patients regarding medical bill disputes. It also takes the provider out of a position to fight with their patients about a bill, which from a patient relations standpoint is a positive thing. The downsides are the provider may see reduced out-of-network reimbursements for these NSA services. As I indicated in the charts, there might be some cash flow delays, increased administrative costs associated with the disclosure requirements and notice and consent that Shay discussed, and staffing the IDR team. If you are a provider who intends to dispute low payments, you may need to reorganize or increase staffing to accommodate for that. At provider agreement renewal time, so we're looking, this is for providers who are in network with commercial insurers. When your provider agreements come up for renewal, you may see, or likely will see, increased leverage by insurance companies to reduce in-network reimbursements due to the median in-network rate being the presumptive out-of-network rate. So insurance companies are now in a position where their middle of the road network rates are the presumptive rates. So if you have particularly like an older contract that you've continued to renew that has favorable reimbursement rates, you may see some increased leverage by insurance companies and some increased push to drive those rates down. And it may result in decreased in-network reimbursements due to the reduced negotiating power. I will say that some providers, some of my clients, and I've seen some news articles in other states, are starting to see the trend already where insurance companies are trying to cancel midterm their provider agreements. Long-term, this is likely going to impact networks, reducing the size of networks where insurance companies try to, obviously Kentucky isn't any willing provider state, so they can't really limit access to the network, but they can, make the requirements to join the network so unfavorable that providers don't want to join. So I think we're going to see some reduced networks. I think you'll see increased hospital subsidy costs to ancillary provider groups. So your rural anesthesiology groups in rural Kentucky, the hospital was supporting the anesthesiologists being located in that area through a subsidy. Now the group also cannot balance bill commercially insured patients. Their cost to operate, or their reimbursements to cover the cost to operate, are going to be reduced. And so you may see some increased hospital subsidy costs related to these ancillary provider groups. And you may also see some elimination or reduction of particularly air ambulance providers and rural provider services. Okay, so far, and this is an important point, I know we're towards the end of this, but we're going to shift gears a little here. We're going to talk about self-pay and uninsured patients. And this is particularly important because the provisions that Shay and I have discussed so far are really only applicable and really only impact out-of-network emergency services, out-of-network ancillary services provided at in-network facilities, and air ambulance services. For self-pay and uninsured patient provisions of the NSA, this impacts all providers. So I believe there was a question that Miranda forwarded to me earlier about fertility and endocrinology. The self-pay provisions apply to you. They're going to apply to cosmetic surgery. They'll apply to weight loss surgery, things that typically have never had to deal with insurance at all. So there are two requirements for self-pay and uninsured patients. The first is a good faith estimate process. And this is going to apply for wholly uninsured patients, insured patients, but for non-covered services. And that's where your fertility and endocrinology, et cetera, comes in. And insured patients, but for services the insured does not want billed to insurance. There's also relevant here is a patient-provider dispute resolution process. So good faith estimates. So the obligation on the provider is to provide a good faith estimate to your cash pay patients. And this has to be provided upon either the scheduling of the item or service or a question regarding the prices of the items or services. And any question regarding a price is deemed under the law to be a request for a good faith estimate. The requirements for a good faith estimate apply to both convening healthcare providers and facilities and co-healthcare providers and facilities. So your convening healthcare provider is basically your primary provider. It's who the patient calls to set up the initial service and likely who they ask about the costs. If there are related services by other healthcare providers that are, intricately intertwined with the primary service, then those are co-health providers, and they must also provide a good faith estimate upon the request and notification from the primary provider. And so a good example of this might be, historically, like a plastic surgeon's office that they do the surgery in the hospital. So the plastic surgery is going to be the primary service. The hospital charge, facility charge component will be the related co-health service. So what you need to provide, as I've said, is the good faith estimate, and that's a notification of the expected charges for a scheduled or requested item or service, including items or services that are reasonably expected to be provided in conjunction with that service. The expected charge is the cash pay rate or rate established by a provider or facility for an uninsured or self-pay individual. So your revenue cycle teams and your patient-facing staff should be thinking about responsibilities regarding these good faith estimates. And so the practice will need to determine if an individual is uninsured or self-pay, if they want the provider or practice to bill insurance, they'll need to inform the patient of the availability of a good faith estimate. It must be in writing, orally provided when schedule an item or service or when questions about the cost of the item or services occur, and accessible in the patient's spoken language. And like I said, any question about a GFE, any question about a cost is deemed to be a request for a GFE. Here are the deadlines. It's quick. We're running out of time, so I'm going to keep moving, but they're up there. You also have obligations as a primary provider with respect to co-providers. So you have to ask the co-providers to provide their estimates. And if you're a co-provider, you have to cooperate with the primary provider to get the estimates to the patients. This is the content of what a good faith estimate looks like. Several line items here, and you can peruse those. Here's the good faith estimate example that's given by CMS. That's the link up there, and here's the provided document by the department. Okay, so in addition, there's also a patient-provider dispute resolution process with regards to cash pay items. It is initiated by the patient. The patient initiates it by submitting a notice to HHS via the same IDR portal that we talked about earlier, where the provider and patient and insurer can dispute. It's available to the patient, like the patient's right to the independent review is triggered if the total billed charges are in the good faith estimate are substantially in excess of, if the total billed charges are substantially in excess of the good faith estimate estimated charges. And substantially in excess under the legal definition is $400 more than the good faith estimate. So not really substantially in excess, just slightly in excess. The deadline is within 120 days of the date the patient received the initial bill. So that's the deadline for the patient to request the dispute resolution. Importantly here, if the patient, your teams need to stay on top of whether patients request patient-provider dispute resolutions, because during the process, you can't engage in collection activity. If you've already sent a bill to collection, you've got to suspend that. Your submission as the provider to the SDR, which is what the entity is called for the patient process, is a copy of the good faith estimate, copy of the billed charges, and documentation demonstrating that the difference between the billed charge and the expected charge reflects the cost of a medically necessary item or service that is based on unforeseen circumstances that could not have reasonably been anticipated. And the deadline for the submission is 10 business days of receipt of the selection notice for the IDR SDR entity. So how will the independent SDR entity hold? What are guidelines on their decisions? If the billed charge is equal to or less than the good faith estimate, the payment will be the billed charge. If the billed charge is greater than the GFE and the provider fails to justify the additional charges, so didn't prove that it was a medically necessary service based on unforeseen circumstances, then the payment will be what the patient owes you, will be the good faith estimate. If the billed charges are greater than the good faith estimate and the provider does justify the additional charges, the payment will be the lesser of the billed charge or the median payment amount by plans in the geographic area as provided by an independent database. If an item or service was not on the good faith estimate, you forgot it or left it out. If you can't prove that it was a medically necessary unforeseen service, the patient is not required to pay you at all. It's zero. If you can justify that it was a medically necessary unforeseen service, then it's the lesser of the billed charge and the information regarding the services in that geographic area in an independent database. The deadline for the decision is 30 days from the date the information to the dispute resolution entity is due. The administrative fee associated with the dispute resolution is fronted by the patient, but if the provider loses, then the amount the patient owes the provider is reduced by the administrative fee, so it's offset. All right, so a lot of information here. What should providers do now? Where do you go from here? Educate your practitioners and revenue cycle team on the NSA requirements. We are finding a surprising number of clients, sophisticated clients, who just aren't quite aware of the total impact of this law. Establish a policy and process for providing disclosure notifications. Establish a process to identify and track claims subject to the NSA prohibition on balance billing. Determine if notice and consent will be obtained, and if so, establish appropriate policies and procedures. Establish or re-educate on policies and procedures for identifying patient insurance coverage. If you weren't adamant about, if your practice wasn't adamant about identifying it up front before, now is a good time to re-educate and have a sense of urgency about identifying the payer sources. For hospitals, you will want to review and update ancillary provider agreements. So your contract service providers, anesthesiologists, ER docs, radiologists, et cetera, you want them to provide notice regarding their network status. You want them to cooperate if you request a good faith estimate because they are the co-provider. You want them to indemnify you for their failure to comply, and probably a myriad of other contract suggestions by your respective legal counsel. You want to identify elective procedures performed in the hospital and determine policies regarding good faith estimates related to those. Establish internal systems to handle the IDR process. This can, like I said, be increasing staffing. It can also be gathering your internal data and materials to support payment rates that are higher than the median contract rate. Gathering information about your past reimbursements, what your network payments looked like in the past, what your out-of-network payments looked like in the past, relevant Medicare rates, and to the extent publicly available, because I am in no way advising and trying to create an antitrust issue here. You want to know what the other providers in your geographic area, to the extent it's publicly available, are charging and receiving for the services. You want to establish and educate your team on policies and procedures related to self-pay and uninsured patients. This is, determining your good faith estimate, policies and procedures, identifying situations when the practice may need to contact a co-provider or co-facility, and identifying items or services provided by the practice that insurance coverage is typically not available. And you may want to update your invoice language. as you see fit. I have recommended to clients to put if in a situation where you are billing the patient, patient, if you have insurance, we are unaware of it, please contact us. If you've received this bill in mistake, it's not effective, please disregard it. Things like that, just some exculpatory language on your invoicing. And that is, for more information. So there are some links here to the relevant laws and some great guidance documents by the relevant departments. And here is mine and Shay's contact information for any additional questions. And I think we have some time for questions now. Are we doing questions now, Miranda? I'm sorry.
Sure. Well, we were going to do questions, but I'll tell you, you've answered all of the questions that have been submitted previously. So I appreciate that you gave us such a comprehensive overview of the No Surprises Act. I don't see any questions in the Q&A. At this point, we have had people request some of the resources that you just showed on the screen, and we will send that out via email to all of the participants today, and they'll be able to check that out on our website as well. So with that, I would just like to thank you all again for giving us all of this time today to spend with our members on this important issue. And to everyone that has attended, please remember to complete your evaluation for CME credit. And once those evaluations have been received, we will email you your CME certificates. So thank you, everyone, and have a great afternoon.
Thanks, everybody.
Thank you.